20-34558 is called the State of Texas versus Eric Wilson. That's you?
Yes, sir.
And Mike Kimberly was your attorney at one time?
I believe he had a court appointed lawyer judge when I was detained, and I filed a notice.
Yeah, then Mr. Hughes is now the attorney.
I sent you a letter to reduce my bonds.
Yeah, Judge, I filed a letter of representation on January 9th of this year.
We got a bunch of long papers here. Here, these aren't for this file. That's Joshua's Idrid.
It's probably just misfiled, Judge.
Yeah, probably. What's the option of that?
Well, we can go.
It's a misfile, isn't it?
And then everything will be in the right now.
Yep. There's a motion to reduce bond here at the top. There's also a motion to revoke probation file September 25th. What are we doing on that?
Your Honor, I believe he spent, I think he got 100.
We got committed the offensive arson. It says
Judge, that case was
criminal
rejected.
Mischief and criminal trespass.
Yes, Your Honor. The arson was refused in Jasper County. I believe he pled to time served on the misdemeanors. They occurred right after he had a serious accident, and I believe he had mental issues as far as right then needing to take medication, all that. I believe his brother was actually an appointed guardian of him right after this. I don't think he had any trouble up to that point.
When did that occur?
In July.
Okay, we've got committed the offense of criminal trespass on or about April 16th in Jasper County. That's number 3. Then they committed the offense of criminal mischief on July 18th.
Yes, just the criminal mischief was.
So what happened in April? That's criminal trespass. And that's
that case was dismissed as well, Judge. He pled guilty to the criminal mischief in July. That he was arrested for in July in Jasper County. And the arson was rejected, and that rejection was not part of any plea agreement. It was rejected and all the plea was entered.
yeah. That's so. What's in this motion?
It is
Criminal trespass.
It lists the arson and the.
I know it does. What's
criminal-
in it that is viable?
The criminal mischief and the criminal trespass.
Criminal mischief occurred on July 18th. I thought there was a problem with that. July 18th. I thought you said that was problematic if it occurred then, right? I mean, is that, are y'all saying that's viable? I thought.
Well, then we'll just go off the criminal trespass, Your Honor, but I know the arson was refused on there.
Okay.
Like I said, that was.
So criminal mischief is still valid, a valid
Yes, that is what.
complaint,
That is what he pled
and
to.
criminal trespass on April 16th is still valid, viable. I guess. What are we doing today? Today.
Any argument for reinstatement? I believe he's been in there 113 days on this here in our jail, and I think 90 days in Jasper, I believe.
It's 113 in Jasper, whatever he's.
Okay, so 113, I'm sorry, in Jasper, and then he's been in here approximately 116 days, I believe, is what I have.
Yes,
So he's been in there quite a while.
Okay,
I think
so-
Mr. Hughes was arguing to continue him on probation. And obviously, we're just putting that to the court, telling you how much time that there was an accident on there. I think he's
Y'all are the ones who brought it. What
willing
y'all
to plead
want?
true
What y'all
to it.
asking for?
it's my understanding that before this happened, he was, Mr. Wilson was doing good information. He was taking time, he was paying.
Well, that's good until they do that.
He was reporting as instructed. The only issue that we had, he was on medication for accident that he had prior to the probation, and he's seeking private care. It was through our probation supervision. And there were some issues where he was possibly hospitalized because he wasn't taking medication as he was supposed to. But and then he also provided me in February medical marijuana prescriptions, which we did. He wasn't driving or anything like that. He had a family friend that was bringing him everywhere, and I did speak with her every month or every other month. I spoke with her, and she was verifying that he wasn't driving. And then that's when the trespass happened, and other stuff happened. And he was reporting and paying his money. And he didn't have any community service, but he wasn't testing positive for any alcohol.
Yeah, I don't really have much supporting those allegations into it. I don't have probable cause or anything. We don't have something like that, so I know, have some idea about.
As far as the Jasper cases, Your Honor.
Yeah, there's criminal trespass here, right? That's what's down all the time. So that happened April 16th. But generally I get a probable cause, a summary or something. This doesn't have anything to do with April. This is something that y'all say is not viable.
I believe Mr. Barksdale has the dispositions and all that, Your Honor, from Jan.
Yeah. Oh, there's an oath. Okay. Complaint states a subject who has an active criminal trespass warning for his address is currently on his back porch banging on the door. All right. Wilson was at the back door and been knocking on the door. Wilson walking to the back door and stating he was wearing a uniform. That's Wilson walking, but taking place and what? Was after the relation. The neighbors. Wilson stated he had not been over there and did not know his city limits. He had not been over there in months. He was on the phone and the phone was on everything down. Then around what Wilson then began rambling about a state trooper from his residence and it was someone stole from his residence. Hmm. Well, they got a video of him in the backyard. Yeah. No. Yeah, no, they do. That's what the police said. They saw it. They're also saying that when you're not taking your medicine, you act on it. Do you take medicine regularly?
This one, I take all the medicine prescribed to me by Dr. Lee, coming to the morning. And when they put the trespassing on me at first, they had a metal steel fence laying on my ball wire fence.
Well, they have a security camera showing. That's what this says,
Yes, sir.
under oath, but I haven't
If you
seen
need those, Your Honor, that's
what it is, but I would talk to him before you start saying things, especially if they've got video evidence. You don't want to say some things that I might find or obvious false statements like what you meant.
I believe they had him plead on the one, Your Honor, and dismissed him on it. So when they refused that,
Larson. Yes.
Well, you're presumed innocent unless found guilty.
Yes.
Hmm. What's anybody want to say?
Since I'd asked. Actually, you didn't say that.
I know you're on, yeah. Well, I think I understood that's what you know. I'm not curious what y'all know. No, especially Mr. Barksdale, you're closest.
Your Honor, I mean, as far as, or when I supervised him from junior to 24 feet, and he was reporting, he was very, I just said respectful, all that, but the only concern I would have is his medication
Yeah.
was taken as
Well, this is
prescribed.
a criminal trespass, and there isn't any allegations of violence or threats, but there's a reason they have that. Is that criminal trespass requirement? Is that requirement not to go to their property? Is that still enforced now? Is that enforced right now, or is that gone? Is that still viable? Do you know? Does anybody know? Did they tell you this was going to be
They told me it was
on order for a while?
They told me it was dismissed because I had called in to the number on the trespassing thing that was the first.
When was it dismissed?
I don't remember the exact
Right.
date. But before then, I had received a mail and put it on the back. And my second cousin next door, her last name was Fluid.
No.
So I knocked on the front door, but never on the
Well,
back.
This is all occurring like almost a year ago. So what's happened lately?
Your Honor, since, the last time I had Mr. Wilson's, it was actually in, May of 25, and that's when we'd done a staffing, about the trespass, because at the time, the trespass wasn't even filed yet with
So
Jasper.
where's he being supervised now? Jasper?
No, sir, he's being supervised
Oh, he
with
comes
us.
here. How often does he come here? Once a month?
He was reporting, his knee every other month.
Every other month? Is he still doing that? Except for being in jail?
Yes, sir, he was reporting every other month.
Okay.
And I believe he's been in there like 200 days, Your Honor. I think it was 100 and something in Jasper and then 100 and something now.
Well, he's, the anniversary of his probation is this May, isn't it?
Yes, sir.
Yes,
Well, what are we gonna do? Stay. What do y'all want to do?
Your Honor, I spoke with Mr. Barksdale. I don't think he's, I think a sanction would be appropriate and to continue
what?
on probation if he's a
Jail
jail term.
jail that he's been served? How long have you been in jail?
Since July the 8th.
Since July 8th?
July
8th was
July.
the most-
July 18th.
Since July 8th?
July 18th.
You think that's enough?
I
me
went
too.
through it since.
But most important thing is I don't want something happening again. It sounds like medication is a key feature in all of this. Do you have requirements? Has the doctor prescribed you certain things? If he has that are related to this
Yes.
conduct, you have to catch up with that and take those regularly, or else that's your fault.
Yes, Your Honor.
Then you get in trouble.
Yes, Your
You
Honor.
can't blame it on an illness or something. If you've been required to take medicine, you have to take it timely
Yes.
as required, or else you end up going to jail. This could happen. So, and you don't want to, you've got enough problems here in the past. Let's stop, move on and do better.
Yes, Your Honor. And I always presented my medication to my probation.
Well, that's good, but
And
I get the sense in jail, you probably have a hard time taking those regularly, right?
yes, Your Honor.
Yeah, see, that's why you don't want to go to jail for another reason.
The good one they was talking about, marijuana prescription. I see a therapist once a week to keep that going. And I meet them in person, and use them on the internet.
Wait, who are you getting the marijuana prescription from?
A therapist, the guy in Houston.
Yeah, well, is he a medical doctor?
Yes, they're all medical doctor. And,
Because I'm not going to prescribe it. I'm
no,
not
it's
going to allow
it's
it to be
not-
prescribed.
It's not smokable. It's like a dream drops that help you go to sleep or something like that, or any bars or nothing as such, Your Honor. And
Yeah, well, cannabis sativa is controlled substance. You gotta run, I mean, does your probation officer know you're doing that?
Yes, I brought it.
Okay. Mr. Barksdale, you're
Your Honor,
updated on the marijuana use?
he provided me this in February of 25. This is one thing, one of the things I did staff in May with my supervisor. And we were gonna send a memo to the court advising of the medical marijuana. We just unfortunately never did because of the fact of the new charges and everything that happened, but he did present this information to me.
You drive a vehicle?
Since I've been.
Hold on.
Since I've been on this, I choose, Petty Heber, Muscat Angel.
Well, you can't operate a motor vehicle.
No, I can't. I passed my driver's license stuff several times.
Huh?
I passed my driver's license.
I don't care. You
Don't drive.
you can't operate a motor vehicle if you're taking marijuana.
Yes, I haven't been.
And I believe his brother's his guardian, Your Honor, and he also has a lady by the name of Peggy Hebert that he stays with. She drives him around, from what I understood.
Yes,
Well, that's important. It's a 4,000-pound missile. You gotta be sober
Yes, ma'am.
and responsible. You can't be taking drugs that can inhibit your ability to operate it safely and save people's lives, plus yourself.
Yes, ma'am.
That's, well, okay, Ms. Foxton, what else do you want to do on this?
As far as the driving, he wasn't driving, at least that's what he's reporting to us. I did talk to Ms. Hebert usually every month or every other month, and she was verifying that he wasn't driving during his office visits. I would.
I know, but how do we know?
Besides that, no, I'm not
Oh,
sure.
no, I don't know. She knows. Here's what, you have to have an interlock device in any vehicle you operate.
Yes, ma'am.
So we know.
Yes, ma'am.
So otherwise, there's really no review. I mean, it's on your terms and we don't have any reason to check on you. And we don't have the ability to check on you if you're not.
I'm sorry, as far as probation, we did get him to sign a no motor vehicle driving restriction form back in February 2025.
Yeah. But, so you can't drive, right? But if you jump in a car, you have to have an interlock device in the vehicle or else that's another problem.
Yes, you.
What else do we want to do? Anything else? So what are we doing? We got a motion to revoke probation here. What do you want to do with it?
Your Honor, we
We've
would,
already explained all the three
I believe
allegations.
we'd be agreed to continue him on there. It looks like he's been doing okay, other than this incident, which was, when he wasn't taking his medication. So I think
He's about to get off probation here in a few months. What do you want to do? What do you want to do?
Well, we can, if you want to continue, I'll still monitor him as far as probation goes.
I know, but what happens on May 21st, on May 12th? Then we'll terminate it?
Yes,
Okay, if he's okay, he's doing fine?
yes, sir.
Okay, then he's back on probation. But you have to follow all the terms and conditions of probation.
Yes, sir.
Plus, you're so close to it. Don't shoot yourself in the foot.
Oh, no, yeah.
No, here you are, you're in front of me in a blue suit. You shot something. A toe anyway is gone. Because you're here.
Yes, sir.
There was some good cause to put you in custody, you don't want to revoke your probation at this stage, right? Oh, okay.
So, moving to,
All right.
Do.
Do better, well, and go in peace.
Yes, sir.
And I'll sign the dismissal.
Thank you.
Excuse me.
Yes, sir. Larry Charles, here's Larry Charles's other file. Rodney Cleveland, that's you?
This one, they literally just gave me an offer this afternoon and I haven't had a chance to convey it to him.
Okay,
So-
so we should go and talk to him here in a
Okay.
minute. Well, let's see what we've got on this.
Yes, sir.
Stand by, sir. He's gonna go talk to you. I've got Travion Cunningham.
That'll be a plea judge.
Okay. Cunningham, please. 25 CR 1660. What are we gonna do? We'll get a file. Oh, that's in the invite. Oh, we got
Yes, sir.
4 different ways he committed the crime, huh?
Yes, sir. He's pleading to the first two. just because otherwise jurisdiction, if you do paragraph 1 and 2 to maintain jurisdiction,
which constitutes what?
continuous violence against the family.
Third degree?
Yes, sir.
Yes, Your Honor, that's great.
Come on up.
Come here, please, sir.
Go to that lady first. That lady, thank you.
Raise your right hand, please. Swear or affirm to tell the truth yourself and God. You have your right thumb pressed, please. Place it flat right there in the box. You get up again. Place it flat right here. Don't roll it, just place it flat. You lose can't do that.
25-0-1660 is called the state of Texas versus Trevon Eugene Cunningham. Right?
Yes, sir.
You're here with Mr. Turkey, your attorney and the state's attorney. What are we doing today? He's charged with third degree felony of continuous violence against family.
Yes, Your Honor. The agreement was 4 years.
No, what are we going to do? It was paragraphs 1 and 2.
Yes, sir.
Yes, Your Honor. That's correct.
Okay, does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about October 18th, 2025 in Jefferson County, Texas, you committed intentionally, knowingly, and recklessly caused bodily injury to a person who you had a dating relationship by striking that person about the head and body with your hands. And on September 20th, 2025, that would be about a month later, you did then and there intentionally, knowingly, and recklessly cause bodily injury to the same person who you had a dating relationship by striking that person about the head and body with your hands. Okay, this count constitutes continuous violence against family relation, and that is a third degree felony. Do you understand what you're charged with here?
Yes, Your Honor.
You face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty and sentenced to 4 years in prison. Is that your understanding of the agreement?
Yes, Your Honor.
If I follow this, you have no right of appeal. Do you understand?
Yes, Your Honor.
How do you plead to this charge, sir? Guilty or not guilty?
Good.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir. Yes, Your Honor.
And those are the allegations that are alleged in paragraphs 1 and 2 here. Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney. Are the contents true and correct? State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, and you've read it. You are guilty of the crime and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. It states so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report, Williams.
Yes, sir.
I'm going to find as follows, sir, in paragraphs 1 and 2. And this is kind of an awkward thing. They've got it in paragraphs 1 and 2. You are pleading guilty in paragraph 1 to an act occurring on or about October 18th, 2025, and true to paragraph 2, an act occurring on or about a month later of intentionally, knowingly, and recklessly causing bodily injury to someone that you had a dating relationship in both of those occasions. You are pleading guilty and true to those allegations, correct, sir?
Yes, sir.
Voluntarily, knowingly, intelligently. And there is sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea, to find you guilty beyond a reasonable doubt. As you are admitting guilt, giving up your rights to a jury trial, and you are totally satisfied with the representation provided by your lawyer. I find all of that true and correct. States Exhibit 1 is made a part of the record. I now find you guilty beyond a reasonable doubt of this third-degree felony as represented in paragraphs 1 and 2 of this indictment for continuous violence against family relationship. And I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. You will be given credit for time you have served in accordance with this case. Do you understand what has happened today, sir?
Yes, sir.
Anything else on this?
Nothing but stay here.
What is on? What is on here? And we call clause number 20-35322, the state of Texas versus Chantilly, Chanel Hunter.
Yes.
Here with Mr. Turk, your attorney, and the state's attorney. There's a motion to revoke probation that's been filed as of November 6, 2025. Have you had a chance to review this with your attorney? Are we ready to proceed here?
Yes.
When I apparently received a letter in gigantic print.
You? That's my handwriting.
Yeah, that's yours. Look at that.
Just apologizing.
Certainly easy to read.
I don't know, that's another, you know, something.
Uh-oh. That one's not so easy to read. No, actually, I mean, that's, again, an easy to read. Uh-oh, we misspelled developing. That's okay. Opportunity, that's a tough word, though.
English has some strange spellings.
The way you speak it,
That's true.
it's foreign language.
I'm doing my best. English is my second language. All of English.
And yeah, but gibberish should not be your first language.
He normally saves those comments from me.
Well, you've been the gibberish coach for the Bar Association for years.
Thank you, Judge. I didn't want to be left out. Appreciate it.
Um, We have in 20-35322 a motion to revoke probation before the court. You're familiar with this, Ms. Hunter, and had a chance to talk to your attorney about it?
Yes.
All right. Please raise your right hand. Do you solemnly swear or affirm any statements you make during this motion to revoke probation hearing will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your head. Can we proceed by summary? Does the defendant waive a formal reading of this motion to revoke probation?
Yes, Judge.
In summary, ma'am, this motion, which was filed on November 6th of 2025, a few months ago, it alleges that on May 20th, 2024, in this criminal district court, you were sentenced to 10 years in prison, and that was suspended for 8 years probation for the second-degree felony of assault on a peace officer. Is that true?
Yes.
Allegation 1 states you committed the offense of criminal trespass on or about January 22nd, 2025 in Harris County, Texas, in violation of condition 1 of your probation order, which states don't commit a crime. Is that true or untrue?
That's true.
Number 2, you failed to avoid injurious or vicious habits as directed by the court by your continued substance abuse of cocaine or methamphetamine in violation of condition 2 of your probation order, and condition 2 of your order of probation states avoid injurious or vicious habits. Is that true?
Yes, sir.
Is that good enough for everybody? Are you pleading true to allegations 1 and 2 voluntarily and because they are true as they are expressed and stated?
Yes, sir.
Do you understand that a voluntary and knowingly made plea of true of one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation now could be revoked, and this is a second-degree felony. You are facing no less than 2 nor more than 10 years confinement in prison. Understanding and appreciating that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. An agreement has been reached in your case where your probation would be revoked. And this says allegations 1 and 5. You pleaded true to 1 and 2. I'm going to correct that.
Okay.
And your probation would be revoked. You would be sentenced to 5 years and
Yeah. Well, this is something.
this is the most awkward device that's ever been invented, truly. I'm trying to erase right now, and if anything you touch on the pad will make a mark. So I've got to put this thing on it, and then you have to press these two little devices at the same time with your one single finger, pressing at the same time to erase. That's how it is. Nonetheless. The agreement is your probation would be revoked. You would be sentenced to 5 years imprisonment, and you would be given time for all credit that you have earned in conjunction with service to that sentence. Is that your understanding?
Yes, sir.
If I follow this agreement, then you have no right of appeal of your case. Do you understand?
Yes, sir.
I'm going to show you here what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
States Exhibit 1 is tendered into evidence.
Objection.
Without objection admitted. Among other things, this states that if I follow this agreement, you understand and swear you understand you have no right of appeal.
Yes, sir.
All right, States Exhibit 1 is made a part of the record among other reasons. I'm going to follow this agreement then and find you have pleaded true in this motion to revoke probation to allegations 1 and 2 voluntarily, knowingly, intelligently. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. Your probation is hereby revoked, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You are given credit for all time you have served in accordance with this case. You understand what has happened today?
Yes, sir.
Anything else to add? Anybody? No? Okay, then we are in recess on this case.
You get your credit for you.
Okay, thank you. Thank you, Judge.
Yes, ma'am.